The question before us is, can we say it law of tort or should we say law of torts? Actually, the definition of tort is based on different theories given by the different jurists. So, few jurists like Salmond and the followers of Salmond says that it is law of torts because according to them, all the torts are predefined and there are a definite number of torts outside which the liability does not exist. If you see Salmon's definition, he defines tort just as the criminal law. In criminal law, there are body of rules and there are specific offenses. So according to Salmon, in torts there is also body of rules and there are specific liabilities. So everything is predefined and the tort becomes a civil wrong, the remedy of which is the common law of action for unliquidated damages. The theory behind law of torts is called the pigeonhole theory because there are neat and clear set of pigeonholes that are imagined, and in each pigeonholes there are separate predefined law of torts. For example, in one hole there may be nuisance, another there may be trespass, another there may be defamation, another there may be liability. According to them, if the civil wrong does not fit into any pigeonholes, then it does not become tort. On the other hand, there is the concept of law of tort, which says that all injuries done by one person towards the another person, if it is unjustified by the law, then it becomes a tort or the civil wrong. So, all unjustifiable harms are tort, and if it is unjustifiable harm, there shall be a remedy, because it is based on the Latin maxim ubi jus ibi remedium, which means that where there is a right, there is a remedy. The follower of this version is Winfield and Pollock. You will find the reflection in the Winfield's definition because, according to him, tortious liability arises from a breach of duty which is primarily fixed by the law. And if this duty towards these persons, which is fixed by law, is breached, then it will be redressable by an action of unliquidated damages. So people who says that the actual term is law of tort, they believe that we cannot free define, confine and crab and cabine any civil wrong under these pigeonholes because they believe that new kinds of torts will arise. And yes, it is actually true because in the 19th century, the tort of negligence arose. In the Raylands versus Fletcher case, we had a new concept of strict liability. And again, in India, in MC Mehta versus Union of India, we had the new concept of absolute liability. Also, if you follow the judgment of P. Rathinam versus Union of India, you will see that the judges has distinguished tort and criminal law liability. To summarize the whole concept, we can say that law of torts is based on the pigeonholes. Anything outside those pigeonholes cannot exist. On the other hand, law of tort is based on all unjustifiable harms, and where there is right, there is remedy. So, law of tort does not predefine and confine the number of torts. New tort may arise with time. If this discussion helps you, subscribe to this channel and like, share and comment your views.